Chapter 13 of Mounted Police Life in Canada. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Mounted Police Life in Canada by Captain Burton Dean. Chapter 13. Mounted Police Law. The raison d'etre of the subject matter of the following chapter is to be found in the circumstances that, at the date of which I speak, the relations of the Mounted Police Courts to the ordinary courts of law stood as an unknown quantity. There was an undefined feeling that they were subject to the control and supervision of the Supreme Court, but the question had never been raised in a concrete form, and neither bench nor bar was interested in the abstract question. I had on one or two occasions noticed on the part of young, aggressive lawyers indications which led me to think that some day the question might be raised in a manner that would call for a pronouncement thereupon by some competent authority, but so far there had been no clash. In the month of November, 1898, however, the monster raised his head in such an uncompromising fashion that something had to be done to settle the dispute for all time. As it happened, it fell to my lot to take the assertive monster in hand, and, as it also happened, perhaps fortunately, it had fallen to my lot to learn in my old corps some military law which no other officer in or connected with the Mounted Police had had occasion or opportunity to learn. The difficulty came to a head in this wise. In November 1898 I was in command of the division at Macleod, as well as of that at Lethbridge, and used to spend 4 days of each week at the former place. Belonging to one of the detachments of the Macleod division was a constable named B.O. Nettleship. It happened that on November 29th this constable would complete the term of service for which he had engaged, and would be entitled to claim his discharge. He had recently come into a legacy of a few $100 and intended to settle in British Columbia. He was a man of whom I personally knew nothing, but his record was good. He had been a handy man in his detachment and was a fairly good axeman, etc., and I felt quite kindly disposed to him. When, therefore, he appeared before me on the morning of November 23rd and asked me to give him leave of absence until the end of his term, and to allow him to "sign off," as it was called, before he left, so that he would not have to come back on the 29th to complete his discharge papers, I cordially agreed. I convened the usual Board of Officers to carry out the regulations in such a case, namely, to verify and record the particulars of the man's service, to adjust his accounts, and to ascertain whether or not he had any claim against the Government in connection with his past service. This was all a pure matter of form, usual in every disciplinary community of which I have had any knowledge, and was designed not only to protect the Government in the future, but to see that the person about to be discharged was in process of receiving all dues that were properly coming to him. During my weekly visit to Macleod I had to compress about a week's work into 4 days, and was naturally kept pretty busy. That afternoon, while in my office, the door between that and the clerk's office being open, I was very much annoyed by the strident tones of a man's voice, which seemed to have a great deal more to say than was necessary. And at last it worked so much upon my nerves that I called to the chief clerk and asked who the man was and why he was talking so much. The sergeant replied that the man was Constable Nettleship, whose discharge papers were being made out by the Board of Officers, and that he was under the influence of liquor. I said, "Send him out of the office at once to return to duty. His pass is cancelled. Let the Sergeant Major know." This was the only alternative to placing the man under arrest on a charge of intoxication, however slight. According to the wording of the Mounted Police Act, I thought that in all probability he would reappear next morning, say he was sorry, and renew his application for leave. I had it vaguely in my mind that if he should do so I would give him his leave and let him go. This, however, proved to be the last thing that Nettleship intended to do, for in the course of the same afternoon he deserted. He went to stay with some friends of his in Macleod, who kept him perdu for a couple of days or so at a great risk to themselves. and then he developed diphtheria. The health officer promptly isolated him in the pest house, and applied to me to make the necessary arrangements for his medical attendance, nursing and maintenance. I replied that a man of the name he mentioned was then in a state of desertion from the North West Mounted Police, and I declined to accept any responsibility for his medical attendance, etc. I added that he was quite able to pay his own expenses. There was at that time living and practising in Macleod a very clever lawyer. To him Nettleship applied for advice in his dilemma. The proposition made was quite simple. Nettleship had money which was burning a hole in his pocket, and his legal adviser was quite willing to relieve him of any inconvenient surplus. The lawyer advised his client that he was no longer a member of the police force, and he may, for aught I know, have honestly believed that the advice he was giving was good. I made no secret of my intention to hold Nettleship accountable for his act of desertion as soon as he should be released from quarantine, and the lawyer then made application to a judge of the Supreme Court, sitting in Calgary, for a writ of prohibition. The affidavits upon which this application was based bristled with falsehoods, and I made a trip to Calgary with material to contradict them. While at Calgary I spent Sunday afternoon with an old Regina friend, Mr. Justice D. L. Scott, and to him I confided my troubles. He listened patiently for a time, and at last said, "Dean, do you mean to tell me that I cannot issue a writ of prohibition to prevent you from doing something that I think you ought not to do?" I replied, "That's exactly what I do mean. So long as I do not exceed my jurisdiction, you have no lawful right whatever to interfere with me." In general terms I explained the situation as I asserted it to be, and he finally said, "Well, if what you say is correct, I suppose there is something in your contention." I had applied to headquarters prior to my visit to Calgary for authority to employ Mr. C. C. McCall, a Calgary lawyer, to represent the Mounted Police in this matter, being well assured that he would at all events have taken some trouble to look into the matter. But he was what the Grits called a Tory, and my application found no favour. The Liberal party was then in power, and wanted every visible fragment of the loaves and fishes. The North West Territories were a sort of private game reserve, operated principally in the interests of the Sifton family, the prominent member of which was the Minister of the Interior in the Dominion Cabinet. I was therefore in no way surprised when I received instructions to employ Mr. A. L. Sifton, who was the Calgary Crown Prosecutor at the time. This gentleman had, in his official capacity, previously mishandled an excellent case for me, so I hardened my heart, left my case in his hands, and returned to my command to work up the case myself. In course of time the case came up for argument in chambers at Calgary, and a lawyer who was present remarked to me afterwards, "If I had not known that Sifton was representing the police, I should have thought he was appearing for the other side." It was no wonder, then, that the rule nisi was issued, and I was prohibited from dealing with Nettleship. The prejudice of the learned judge obtruded in every line. He set up a man of straw and battered him out of all recognition, to the admiration and delight of counsel on both sides. In the meantime I had laid a charge of perjury against Nettleship on one of the many false statements in his numerous affidavits, and insisted the Crown Prosecutor at Lethbridge, Mr. C. F. P. Conybeare, K.C., to appear for the Crown. The charge was fully proved by the only two witnesses, besides Nettleship, who knew the facts, who positively contradicted the accused. But the judge showed his bias again, took the case from the jury and directed them to return a verdict of not guilty, which they did. Then Mr. Conybeare, as instructed by myself, gave notice of appeal to the court in Banco against the writ of prohibition. We had got on to a business footing at last, and the ball was with me. My friend Conybeare had the most excellent law library, which he placed unreservedly at my disposal, and during the ensuing weeks I made full use of it, and burnt many gallons of midnight oil in preparing that which would effectively call my opponent's bluff. On March 10, 1899, I was ready for the fray, for on that day I dated to the Commissioner of the Mounted Police a letter which epitomised the results of my labours and researches. This letter, I knew, would be referred to the Department of Justice at Ottawa, and from there it was forwarded to Mr. A. L. Sifton at Calgary to prosecute the appeal. That gentleman could not, without breach of professional etiquette, take out of Mr. Conybeare's hands the actions which the latter had initiated, and so, fortunately, we were able to travel still along business lines. The letter contained a good deal of interesting matter, dicta of eminent English judges, and so forth, known to an extremely limited circle of professional men in the North West, but as the text is by far too long to be here reproduced in extenso, I shall here mention only that, after having marshalled my evidence, I concluded by saying: I submit that the North West Mounted Police, if not a military body, are as nearly military as it is possible for an armed body of constabulary to be; that the statute, by virtue of which they exist, enjoins and provides for the maintenance of discipline, and that their discipline is essentially of a military character. Their regulations respecting the grant of an indulgence of a pass, and the form of pass itself, are adopted from those in vogue in the British Army. They are purely matters affecting the interior economy and discipline of the North West Mounted Police. Similarly, the regulations and customs affecting the grant of discharge from the force are a question of interior economy and discipline. The question of the pass is the crux of the whole matter, for, apart from that, the question of the discharge would never have been raised. It is clear from the learned judge's minutes of judgment that the questions of pass and discharge must stand or fall together. This being so, I am entitled to contend, on the lines of Chief Baron Kelly's judgment, that the issue and subsequent cancellation of Constable Nettleship's pass affected a police indulgence granted by a police officer in his capacity of commanding officer of police to a police constable admittedly under his command, and that the question being thus purely of a police character, involving a question of police discipline alone, is cognizable only by a police tribunal and not by a court of law. An eminent grit lawyer and politician in Macleod, Mr. Malcolm Mackenzie, to whom I showed my letter, remarked as he handed it back to me: "If your counsel does nothing more than take that letter into court and read it, he cannot lose his case. It is not a brief, it is a complete argument." The case for the Mounted Police was very ably represented by Mr. Conybeare to the court in Banco at Regina. One of the judges, Mr. Justice Maguire, had apparently heard Judge Rouleau's side of the story, and interjected so many interruptions to Mr. Conybeare while he was speaking that, to use the expression of a lawyer who was present and told me afterwards, he almost heckled him. However, Mr. Conybeare withstood the ordeal with unshaken imperturbability, and the end of it was that Mr. Justice Maguire, after Judge Wetmore had written the judgment of the court, added a judgment of his own, giving reasons additional to those given by the court why the writ of prohibition should be quashed. It would be too tedious to set forth these judgments at length. The judgment of the court, as rendered by Judge Wetmore, concluded in the following words: "This being so, we must find that the order of Mr. Justice Rouleau was granted incautiously, and, in view of what appears above, it is not considered necessary to allude to any other questions raised in the appeal. The judgment of the court is, that the order granted by the learned judge be rescinded, and the writ of prohibition issued thereon and all proceedings thereunder set aside, with costs to be paid by the respondent." When Nettleship's counsel was subsequently notified of this issue, all that he had to say was, "Oh, well, I got all that I wanted out of it." His advocacy was said to have netted him from $1,200 to $1,300. He had the money and Nettleship had the experience. Previously it had been the other way about. To arrest Nettleship and prosecute him for his desertion would, I thought, have looked like a persecution. so I took no steps to carry into effect the logical sequence of the full Court's dicta. I looked at Nettleship in a quite impersonal light. What I was wholly and solely concerned with was to place the Mounted Police Courts on a solid footing, and I think most readers will agree with me that some such step was imperatively necessary. CHAPTER XIV.